Any mention?
Lordship, I would like to mention item number 22, Your Lordship. That is a hearing matter, Your Lordship. Mr. Ramchandra was supposed. Court number one.
bench. You have mentioned even a single bench sits.
Item number 1.
Extremely sorry, Your Lordship.
Lordship, we have taken steps on all the private respondents, Your Lordship, on 27/8.
Where's the service report? After service, you're supposed to file if necessary. No report has not been served as yet. Had it been served?
Your Lordship, we have taken only on 27/8, so we'll be filing
27/8, okay.
27. We'll be
MS,
filing
yes,
affidavit, Your Lordship.
It is submitted. Steps have been taken on 27/8. On the respondents 9 to 14.
Your Lordship, all the respondents.
It's up to 2 weeks for service report is.
Highly obliged.
Anything else, Mr. Shulai?
No, Your Lordship.
That's it. Musical chairs.
Any mention?
Hearing.
Item number 1.
May it please, Lordship. Lordship, this is a PIL pertaining to the felling of trees, Lordship, and it at Lower New Colony in Limekra, Lordship.
At the
Lower New Colony, Lordship. Lordship, however, the state respondents have filed their objection, Lordship, to which we are yet to reply. Lordship, I'm
you
praying.
filed your counter.
Lordship, yes.
I'm praying for.
What did they say?
Lordship is, in fact, in my humble
Why
understanding.
felling those trees?
No, it has been done, Your Lordship. In fact, Lordship, this is not a public interest litigation. In fact, it is a private
There stand, Lordship.
interest litigation. If you kindly have a look at page 45, annexure 12 of the state affidavit.
Need to file reply.
Lordship, Lordship,
Absolutely necessary.
Lordship, it's necessary.
45.
Lordship, yes. And this is the letter addressed by the PIL petitioner, Your Lordship, to the Chief Conservator of Forests.
Healthy point in the land.
If Lordship is pleased to see a second paragraph of that letter.
Both of them is not to be cut to local authorities.
Lordship, this is a general complaint for not cutting down the tree, Lordship.
This is the PIL, Your Lordship, arose out of this letter, Your Lordship, because
One tree only.
Lordship, in fact, after that, they have felled 6 trees, Lordship, 6 healthy trees.
other
That
three
is
are
there,
there, Your
Lordship, in
Lordship.
my
That has been done,
annexure,
Your
Lordship, annexure-
after
annexure
duly and
one,
after
Lordship,
inquiry
page
has been
20.
done, Your Lordship, because those trees, Your Lordship, they pose danger, Your Lordship, to the pedestrian, to the vehicle, to the locality. They have been done, Your Lordship. Proper
And these are
inquiry
healthy
had
trees,
been.
Lordship.
What do you want to put in rejoinder, Mr. Chanda?
Lordship,
What do you want to put in rejoinder?
we have some,
Anything that's new that you can add to refute this.
Lordship, we'll take instructions, Lordship, we have.
If
our
Lordship
team,
finally
Lordship.
come to
Mr. S. Chanda, to the affidavit filed by the state respondent, praise that you don't obtain instructions. Whether to withdraw a PIL or not.
Lordship,
Take instructions, okay. Yes, after 2 weeks.
Obla, Your Lordship.
yeah, Lordship.
Item
My lords, I am appearing for the petitioner, my lords. If I may just submit. My lords, this argument has been ripe for arguments. This matter has been ripe for arguments for the past 6 months, my lords. My lords would recall on 19th when it was listed. Unfortunately, the matter could not be argued since the papers were not available with this honorable court. Therefore, it was indicated that the matter will be posted for final disposal. My only request, my lords, if a short date be given for final disposal, both sides, I believe, are ready for arguments. The only issue is if it can be listed for final disposal specifically at a short date. Today, it was just listed out of turn. So I would just request this short accommodation.
Yes, Mr. Khan.
My lord,
Yes, Mr. Arvind General.
we have no difficulty, my lord. Your lordship may have a date, whatever convenient to your lordship.
Okay, at the request of the parties, list this matter. We'll give the date on so and so for final hearing. Yes.
My lords, if I may request an earliest date.
You
earliest
kindly
possible date.
you consult with the opposite parties, so we have a convenient date, so no adjournment will be taken on next day.
Convenient. 19th, your lordship may have it on
19th.
19th also.
19th of?
My lords,
19th.
my lords, if I may request
This month,
25th of September.
Okay, 25th September. Very good.
Okay. Grateful, my lord.
September.
Lord, item 3, I am the petitioner, my lord. Connected matter.
Same day. That also, this together also on 25th September for hearing. Was already in the hearing list.
It's in the hearing list.
Grateful, my lord.
Yes. Are you keeping?
Pronouncement of judgment, item number 1.
Approval of the impugn order dated 25/7/2024 does not, however, make any allegations of any fraud being committed or that there was any collusion, but the entire alleged infraction is based on the breach of the agreed terms of reference, non-fulfillment of minimum deliverables, non-remediation deficiencies, delay in delivery, and attempt to take undue advantage in the bills raised for services in advance of the payments being made. Placing the facts in the incident case against the judgments that have been quoted above, dispute between the parties cannot be set or held in fraudulent or affected public interest to such an extent as to warrant the blacklisting or the abandonment of the petitioner. No doubt issues have arisen which have caused setback to the project, but in considered view of this court, the blacklisting petitioner is disproportionate to infractions as alleged. In the mind of the court and the backdrop of the facts, circumstances that have been set forth, the nature of the dispute, therefore, is not one which cannot be resolved by resorting to the terms contained in the contract itself, which has already provided for an inbuilt dispute resolution mechanism. Clause 41.5 thereof has mandated disputes can be settled by arbitration as provided for the manner and procedure to be adopted. As such, in view of observations, discussions made and above, on the given facts and circumstances of the case, the penalty of blacklisting inflicted upon petitioner is deemed unreasonable and disproportionate, and impugn order dated so-and-so according to the quashed, leaving the parties to reveal alternate dispute resolution as contained in the term of contract itself, remains allowed as disposal.
May it please your lordship,
Yes.
the blacklisting has been quashed, my lord, but there
Yeah.
are claims. There are claims in the.
No, that is there.
financial-
Here, that is there. Made that clear.
That right may kindly be. That
It's
right
already
can be
there.
kindly
As a leaving the
That
parties to
right-
appeal or the dispute resolution as contained in the terms. You see, para 15, I already noted all your
Your lordship,
deficiencies,
protect to
delivery.
that extent, your lordship protect the state. To that
Yes,
extent
yes.
only, my lord.
Any mention?
May I please, your lordship?
Yes.
Lordship, I would like to mention item number 22, your lordship. It is a hearing matter, your lordship.
Yes.
Mr. M. Chanda was supposed to argue the matter, your lordship, but unfortunately,
Yes,
he
who's
is not
there?
doing well.
And the correspondent. He's not feeling well.
Consent has been taken.
After 2 weeks,
Consent is
3 weeks.
Okay.
Yes, 3 weeks.
3 weeks, your lordship. Obliged, your lordship.
Yes.
Please, Your Lordship, I beg to mention item number 27. Number 27, Your Lordship. Kindly grant us 2 weeks time, Your Lordship.
Yeah, for whom?
For a petitioner, Your Lordship.
I'm not aware, Lordship. They didn't inform that it'll be taking time.
Okay, no objection.
As of now, no objection.
2 weeks, yes.
Much obliged,
Yes, Your
Lordship.
Lordship.
You informed before you mentioned.
Yes, Your Lordship.
No.
May it please your lordship, I beg to mention item number 25, your lordship. The conducting counsel is indisposed, your lordship.
To Mr. Joshi,
Yes, your lordship. 2 weeks.
who's
time.
other side? You informed them?
Yes, your lordship.
You've informed them?
Yes, your lordship.
2 weeks, okay, yes.
Similar prayer for item number 26, your lordship.
2 weeks, okay.
Oblige, your lordship.
Item number 1.
Number 1, number 2. Number 2.
Item number 2.
Wait, please, Lordship. Lordship, I filed this contempt petition against which by the respondent. Lordship, may I brief your Lordship that during the course of the proceedings, a different direction was being drawn by the
Which order you come against?
order was by
Seeking, saying that they violated?
Your Lordship, this writ petition number 320 was that issue regarding the unregistered organization. They have filed a writ petition. However, Your Lordship, in the order has given direction for the respondent number 3 in the writ petition, which is the KHADC, to dispose of the matter within 3 months. So, Your Lordship, we waited for the 3 months. However, Your Lordship, during issuance of a notice to the parties in before the proceedings in writ petition number 320, certain other private individual were served with notice. So they made appearance before the KCDC, who is the respondent number 3 before in writ petition number 320. So, Your Lordship, the private person also they appear, and even the parties before in the writ proceedings. So, Your Lordship, during the entire proceedings for settlement of the illegal removal of the headman, Your Lordship, we were allowed to file certain documents by way of statement as the position, so to clear up the entire issue with respect to the illegal removal of the headman. However, Your Honor, the petitioner deviated. The petitioner is one of the recipient of the notice issued by the KCDC. Your Lordship, may kindly refer to page 23, which is the initial.
So are the proceedings going on or not?
Yes, Your Lordship. The findings was that, Your Lordship.
Have they completed?
Yes, Your Lordship. But the main observation made by the KCDC, Your Lordship, by the respondent was that they gave a direction. They gave a direction to file a proper application before one of the proper party, who is the main and necessary party.
If you agree with the violation, it has to be willful, that nothing was done. Now, if you say that now this order is dated 2nd and they've already disposed of in July, if I can see is correct, then what contempt is there? Then you challenge this order.
Yes, Your Lordship.
Proceeding.
Your Lordship, but there's been action of biasness and misconstruing of the entire order of Your Lordship.
You withdraw this contempt. Then you file a proper petition if you want, if you are still aggrieved. How contempt is very straight between the court and the contemptor. You have only the only duty of the petitioner is to bring the notice of the court that this order was passed by this court and it has not been complied with. Then the court will deal with its own terms, will summon the contemptor whether it's done or not. If you see there's no willful violation, that actions were taken pursuant to the order, there's no contempt made out.
Your Lordship, but there has been entirely
contempt to twist the arms of people to pass orders in your favor.
Your Lordship, but the cause of action is there, Your Lordship, because there has been a misconstruing of the entire direction given by Your Lordship.
Then you have to file a fresh proceeding. It's not a question of willful. Whatever they've done in their own understanding.
But Your Lordship, let me just read the last portion, Your Lordship, which is at page 25. To the last portion, Your Lordship, where the Executive Committee of KCDC, having considered from all angles procedural of the written arguments of the parties concerned, taking into consideration the order of the Honorable High Court.
Yes.
And so hence, Executive Committee directed the removed family to file a proper application before the HEMA to look into Your Lordship. The HEMA, that means it's Zalindo, who is also the manager and he is also the administrator of the entire HEMA. And the representative of the HEMA, Your Lordship, is.
You take a call, otherwise no contempt made out, we'll close it and leaving you liberty to avail of any other remedy. Approval of the petition of the order stated violated and approval of the order which is stated to be in violation of this court's order does not reflect that there's any willful contempt, but the Executive Committee, in its own understanding, of the scope of the matter is directed. No contempt has been made out. The parties at liberty to.
Your Lordship, prior to Your Lordship, because Your Lordship, there has been observation made which is not entirely of the illegal removal of the headman, which was the main controversial issue before the writ.
That's what you're arguing now is a totally different cause. It's a totally different thing altogether. A new dimension has been opened.
Yes, Your Lordship.
Right, then, so otherwise you don't press it and you file a fresh proceeding. Yes, Mr. Aslindo was after some experience. He's not willing to press a contempt and that he will avail of alternate remedy. Means the son's close disposal. Submissions of the
Item number 3.
This is the case, my lord. Three issues were raised, my lord. One of the issues is pending departmental proceeding. He has been placed under suspension, my lord, way back in 2006.
Yes, yes.
So in the meantime, my lord, there was my
authorities.
My submission.
What about the status? What is the status of the case?
It's still at the evidence stage.
Evidence stage.
My lord, so far the inquiry is concerned, my lord, inquiry has been completed. Inquiry report has been drawn up. After that, my lord, managing committee changes from time to time. One of the managing committee.
You already made a submission.
No, I have got the record, your lordships. That his participation is there. This is the inquiry report, my lord. If your lordship look into the flag mark portions, your lordship, his participation was there.
He took part
Yes, my lord. Lordship will
till the
kindly-
end. What about the other people? There are so many other co-conspirators. What happened to them?
They are also under suspension, my lord.
All under suspension. They are facing, my lord, they are facing trial. This is the situation. Now, my lord, at this stage, my lord, as I prayed, my lord,
Five. You mean to say that the inquiry report was submitted before the authorities as far back 25th November 2006?
in fact, this is the truth. And at that point of time, the committee, my lord, appreciating the fact that he is already facing trial, my lord, kept it in abeyance. Now, the new committee, my lord, they have taken a decision, my lord, that is not a where we can proceed. So that's why, my lord, I am praying just 3 months' time, your lordship. We'll take a call, my lord. We'll issue a copy to the writ petitioner, my lord. Whatever representation, my lord, how he is prejudiced, my lord, he can point out. And then we'll take a final call.
My
This
lord,
we are
at
asking
this
for 3
belated
months now.
stage, my lord, they will provide the inquiry report, my lord, which has been concluded in 2006, my lord. It is not
Thing is
permissible.
that one thing, MS Datta, is that it's not a question he needs to appear anymore because it's already appeared.
He appeared only on
deposed.
one occasion, my lord. Only the first show cause notice was
Yes,
issued. After
he is
that,
deposed.
no witness was examined, my lord.
There he can say, my lord, after the
No
inquiry
list
report,
of
my lord,
witness,
what is the
no
problem?
charge, article of charge has been given to him, my lord.
So you paid the subsistence. Okay, then let's see what happened 24. Grant in aid. Mr. Sen, what records show, but after 2006, nothing was done.
After 2006.
After inquiry report submitted, it's
No,
not
no,
there.
that's what I'm saying, my lord. We have kept it in abeyance. Then managing committee. If this managing committee
Do you have
changes,
any authority to show that it is dominant, might have been concluded irregularly or regularly, that is subject to, debate later on. But whether the inquiry had concluded, you say, at a point of time.
okay. So far, inquiry was concluded, but the disciplinary authority has not taken a call because there is the second shortage stage comes, my lord. We'll have to issue a copy of this, then we will file a representation, and then we'll have to take a decision. Now, that part was not done. So what I pray, my lord,
I know one thing. To reinstate him, you can revive the inquiry.
My lord, if I can just make a suggestion, your lordship, just make a suggestion.
Yes.
So far, other issues might not stand resolved. No problem.
Stand resolved.
Lordship,
Only subsistence stand resolved.
subsistence allowance, his allegation is this was not paid in time. Now, this is dependent on the government. Whenever government releases, we pay.
No,
Some tiny areas where they have been paid.
We're not concerned about that. We are what we're concerned with that a person was suspended in 2006.
Lordship.
As the department proceedings were instituted, from that stage has been kept suspended animation till today.
Listen,
Is it possible? That's one.
There's only one thing Lordship will appreciate, my lord, this man is facing, my lord, criminal trial. And this charges are very serious.
He's facing a standard of proof in
This-
criminal trial is much
this-
higher, standard of proof is lower. You could have maybe at your own level, you could have said that maybe he didn't sign a check as per the other who corroborated his statement. He is a very small man in the entire picture. The other people who signed the check for totally different
They're also
people.
under suspension. Well, now the thing is, this
Yeah.
they are facing trial. Now, my only suggestion is, Lordship. Now, this inquiry report has been drawn up, my lord. We'll take a call, my lord, within a very short time. Give us three months time, my lord. We'll take a final call. We are unable to conclude it.
You
Then
know,
you are
you-
unable to
you-
he'll come
you-
back.
Then we proceed on inquiry from the stage is stopped, even though it's about how many? 24 to now 18 years.
My lord, 18 years, my lord.
Lordship, just 3 months time. We'll take a call. We are unable to conclude it. Lordship,
Lordship,
we'll come back.
I may be allowed to place all
Yes,
these
please,
charges.
that's what, please. This is not a case, it's a strange case. It's not a case where proceedings are drawn up and inquiries are conducted. This is a case of proceedings are drawn up, their statements were recorded, the inquiry officer gave a report, might be maybe not in the correct form, but then like these checks were examined from the documents.
Lordship.
I mean, like the statements were recorded and whatever they've, whatever it is, they've recorded and he's generated a report and handed it over to you. That's all. Right. If it's a case of like the inquiry stopped, it's not like that. Yes.
My lord, 1998 4 SCC, my lord, 154, my lord.
1998-4.
My lord.
Yes.
Says the delay in conclusion of disciplinary proceedings which vitiates the, my lord, the entire proceedings. My lord. It's
See, there's no settled law also regarding
My
There's no settle.
this
Because I have-
case.
I have a
There's no because usually it's like in order delay in concluding the. I mean, it goes on, but here inquiry is over. It's only pays for
My
the
lord,
authority.
if the delay is unexplained, my lord,
My lord,
the proceeding has to
all
be
these cases where, my lord,
quashed, my lord.
on the ground of delay court interfere, there was no proceeding initiated. And my lord, there are cases also, my lord, I have one, where the Supreme Court has held, my lord, there is a situation, my lord, where even after acquittal, my lord, an appeal was filed by the state, my lord.
We'll quash the because in order delay we'll quash them. Then.
My lord, I'll pray, my lord, just 3 months time, my lord, nothing will happen. We'll give him the opportunity, we'll take a call. If we unable to conclude it, then Lordship will say, my lord, that he will be reinstated.
My lord, this belated
So
stage, my lord,
that
is
will
not
be
permissible.
appropriate, your lordships.
In which paragraph of your judgment? 98-4.
My lord. My lord, para 19. my lord.
Para 19.
May I read, my lord?
Yes. Yes.
It is not possible to lay down any procedural principle applicable to all cases and in all situations where there is delay in concluding the disciplinary proceedings. Whether on that ground the disciplinary proceedings are to be terminated, each case has to be examined on the facts and circumstances in that case. The essence of the matter is that the court weigh them to determine if it is in the interest of clean and honest administration that the disciplinary proceedings should be allowed to terminate after delay, particularly when the delay is abnormal and there is no explanation for the delay. The delinquent employee has the right that the disciplinary proceeding against him are concluded expeditiously and he is not made to under mental agony and also monetary loss when there are unnecessarily prolonged without any fault on his part in delaying the proceedings.
One thing, Mr. Senior produced reports of your internal orders seeking to revive, the US is seeking to revive the inquiry, to take it forward from the inquiry report. There are no documents here.
Regarding, my lord, that,
You said there's a new dispensation. He said they will take up the matter.
yes, my lord, that decision, of course, my lord, right now is not,
Not
but they have
decision.
taken a decision. And I have stated in my affidavit. I've stated in my affidavit. But Lordship can anyway bind us, my lord. 3 months' time, Lordship can, my lord, bind us that within 3 months, take a decision, failing which, my lord, will come back.
Very interesting finding against your client. I can read out. That Sri Ashok Kumar Roy may have forged signatures and had often been seen practicing in handwriting book. so, so he was practicing in handwriting book. But it does not exhibit it as whose signature he is practicing. Maybe his own signature is practicing. Right, we'll pass orders then. I don't think we'll question them because the inquiry has been completed. But let them,
But
let
all
them
that 3
expedite
months,
it. But the way the inquiry was conducted, I think
we don't know, my lord, what
that report will be given to you. Will you?
Yes, we'll give.
My lord,
No.
my lord,
We'll do one thing. Yes, we'll do one thing. We won't conclude the matter. You take a decision, and if you what action you propose to take on an inquiry, whatever how big inquiry it is, and you give copies to them.
No, copy. We are under obligation.
my
We'll
lord,
issue.
may I submit, my lord. My lord, that proceeding also has to be conducted as per the Rule 9 of the Assam Disciplinary Rules. my
Of
lord.
course.
That has not been done, my lord, in
No,
my case.
that's why to challenge it, you have to give a copy of inquiry report. No? Then the whole thing will be. I'm not saying anything now, but then the thing
lord.
that you challenge is take
No,
the-
my, so far the copy is concerned, my lord, the college will issue the copy.
no, you have to take a call first on an inquiry.
Lordship.
You have to take a call first on inquiry has been submitted in 2006. Now, whether you propose to move forward with this one or you exonerate them.
No, my lord,
So
we
if you exonerate them, then
My
fine.
lord, the
then-
inquiry report, my lord, has not been provided to
No,
me
no,
till
no.
date, my lord.
If they propose to punish you, then they have to give you a copy.
yes.
My lord.
Right? That's the thing.
No, no, my
Take
lord,
down.
I have made a statement. Your
I'm
Lordship.
being very lenient, Mr. Sen. Don't make any more
We
submission.
have taken a decision, Lordship.
That's fine. You have not given it right. Take down. Stop. The petitioner has filed the incident application. The quarters, he's staying in Column chain of quarters.
Yes, my lord.
I find incident sealing the decision of the respondent number. His respond number, Lady King's respond number,
3,
3, 4, and 5. Linda sealing. Evidence also. There is petitioner. Private instant petition has made for recall and withdrawal of pension order dated 10/8/2006, and also the eviction notice dated 26/2/2024. issued by respondent 3, 4, and 5. Stop. Next part, it appears that the writ petitioner was placed under suspension. It appears that the petitioner who was appointed as a Law Division Assistant (LDA) was placed under suspension as far back as in 9/6/2006, whereafter departmental inquiry had been instituted. As the allegations were of a criminal nature with regard to misappropriation and fraudulent and forgery, cases, FIRs also filed and cases are registered which are still pending before the court of the judicial magistrate first class, and that is case number
GR case number 68.
GR case number
68.
is reported that is a stage of evidence. Next paragraph. This court notes and on the submissions of the parties that though the disciplinary proceedings had been initiated as far back 2006, the same is yet to be concluded or any orders passed thereon by the disciplinary authority. Stop. These are photocopy of the records. A photocopy of the records has been produced today by lead counsel for respondent 3, 4, and 5, which on perusal thereof shows that an inquiry report had been submitted as far back as on 25/11/2006. However, after the said inquiry report had been generated, no further action was taken by the respondent 3, 4, and 5. It is submitted due to the pendency of the criminal case, against the petitioner. Next paragraph. Ms. SN, on being queried by the court as to the long delay, which remains a long delay, has prayed that the response number 3, 4, and 5 be allowed 3 months' time to conclude the proceedings, inasmuch as the charges against the delinquent employees are of serious nature. He reiterates submissions that the delay was not deliberate, but due to understanding that due to the current proceedings that are underway. So that's what Ms. Arbata, then counsel for the petitioner, has submitted that the long, inordinate, and unexplained delay, that submits that on the long, inordinate, and unexplained delay, the disciplinary proceedings liable to be washed forthwith, and the petitioner reinstated in service with all back wages. She further submits that even the inquiry that had been conducted was not in accordance with the that procedure, inasmuch as the petitioner was not afforded adequate opportunity to defend himself. So, therefore, prays that the will be quashed, as also the eviction notice, and that bishop is instated stuff. I think we can dispose it off. We'll have any cause of action.
Only one thing I point out, well, so far quashing is concerned, there is no prayer for quashing.
My lord, it's there, my lord.
He asked for withdrawal of suspension.
Withdrawal of suspension.
My lord, it is there, my lord, in the prayer, my lord.
Okay, yes. Not having heard the counsel for the
Lordship can dispose of.
For the parties, and on perusal of the records by the respondent to 3, 4, and 5, it is seen that the charges against the writ petitioner, amongst others, is for fraudulent encashment of checks of the college funds from Canara Bank extension counter. From the records thereof, it further shows that the writ petitioner, among others, other employees stated to be involved, had been summoned, and the statements recorded. So, the inquiry report thereafter was submitted to the college authorities. The inquiry report dated 25th November 2006 was thereafter submitted to college authorities, and the same has not seen the light of day till date. So, on these circumstances, and considering the nature of the infraction as alleged, as also the submission of the learned counsel petitioner that the inquiry was not as per the procedure, this court at this stage directs the response 3 and 5 to complete the inquiry proceedings based on an inquiry report dated 25/11/2006 within a period of 8 weeks from today. Any proposed action is communicated to the writ petitioner, who shall thereafter be afforded adequate opportunity to represent against the same.
If I may humbly submit, my lord, only he is retiring next year, my lord, May 2025, my lord.
Fine. So
My
now
lord,
it's 8
only
weeks.
few months left, my lord,
No, next year retiring in
in the month of May, my lord.
May. Fine. We'll finish up within 8 weeks.
Why not? We know where we stand. We'll do it.
And then, like, if within 8 weeks, yes. This order has been passed considering the circumstances of the case and the nature of the charges which have been drawn up against the writ petitioner and other. You can't say co-accused. What do you call them? And other employees have been similarly charged. Yes.
Regarding the state, your lordship, it may also be mentioned that there is no
Yes,
grievance against the state.
maybe added
They've
herein
paid the
that
dues.
on the prayer of the non-payment of substance allowance, it has been submitted both by the EAG and by Mr. Sen that the release of the same is subject to the funds which are made available to the college.
Yes, made by the government.
However,
Payment has been made.
however, the response are to ensure that there is no delay in the payment of the substance allowance to the petitioner while the matter is still under consideration. Yes, that the stance is pulled up.
Item number 4.
Inquiry report, I'll take back. Inquiry report.
Take it back.
I'll do within a month, my lord.
No, my lord, 8 weeks, my lord.
I think yes, make it 6 weeks, yes.
Well, 8 weeks is all right.
6 weeks. You only have inquiry report, you have one meeting only. And of the record, your inquiry is.
Obliging.
Yes.
Item number 4.
Election case. Election.
Was it for today?
It's fixed for evidence,
Affidavit.
Well, at the outset, my lord,
Where's the evidence affidavit? You have filed it.
we have not filed it, my lord.
Why?
Despite giving a submission, we are filing it in the course of the day on the last occasion.
Then we will inflict cost, Mr.
My lord, here what had happened, my lord, we had to withdraw it from withdraw from filing, my lord, because of the issue. My lord, the affidavits are ready for now.
We can't. Where's the application?
We are filing it today, my lord, in the course
Where's
of
the application seeking the permission of the court to, for extended time for affidavit?
my lord, we are filing it. We are filing it today.
It's not the way to conduct election petition.
But as a matter of, we propose to file, my lord, the evidence of all the witnesses, my lord, in one go, my lord.
Yeah?
In one go, my lord, we propose to file.
I don't know whether
evidence of all
one
the-
go and two goes.
I'm praying for a day's accommodation, my lord. We are filing it today, my lord. We'll serve a copy on the other side as well.
25-6. Those matters fixed for examination witnesses. Mr. K. Paul, it's not evidence, it's not process of being finalized or filing.
So only certain fine tuning is required, my lord. We are filing, we'll file it.
Are you interested in pursuing the matter?
Yes, my lord.
Very much. Then you, by your conduct, it doesn't seem so.
My lord,
This court was ready to take up the matters.
absolutely.
And there's been repeated adjournments, from.
My lord, from our end, there are only two witnesses, my lord.
It doesn't matter. Then bring them now. Forget the evidence. We'll give them a go by. We can file it, return, let them.
They can do oral also.
My lord, if
Are they here?
they are not here, my lord, he resides in a far off place, my lord, the petitioner.
What is the main ground of challenge?
At that, my lord, mock test, old results.
EVM machine.
Yes, my lord. That was also considered for the purpose
And how many
of
official witnesses have you called?
official witnesses, my lord. I think there are 2 or 3, my lord. That's for the ECI to bring in.
No. You have to bring.
We have to bring, no?
You are going to.
Yes, yes.
Like there'll be okay witnesses, but then who are the official witnesses you think are necessary?
Mainly the presiding officer, my lord, on that particular day. A week's time, my lord, we'll file all the evidences at one go, my lord.
Now it's September. Now these matters are filed April 23. This is no more issue with presentation. There are no issues here with presentation and verification.
No, my lord. Nothing of that sort. Only, my lord, we are confined to the aspect of mock test result being considered even for deciding the final outcome.
The only thing is that they use the same machine
Yes,
without refreshing it.
yes.
But that contention, you'll also say 56.
Then for you, it will be hardly anything to say.
Yes.
Right?
There's
For-
nothing. In
for
fact,
actual-
It's all technical, my lord. And moreover, my lord, the defeat margin was very less.
how many votes?
110.
110, my lord.
Even 56 both added also then it doesn't come.
Because if all the 110 mock test results got into his favor, my lord, then the result would have been outcome otherwise. We'll file the adjournment application for today, my lord.
Actually, Mr. Thapar is giving too much.
I bow down, my lord.
If you hadn't filed, you should have put adjourned petition now only.
I bow down.
Even the lower court also won't give submissions first and say that the application come. In fact, what pass order, let them file it first. We take it up, yes, and put board. We won't call it anymore. You file application, we pass orders on it.
My lord.
Item number 5.
It's a contempt petition, my lord. They've taken time on the last occasion for filing a rejoinder.
Who's for the petitioner?
Miss S. Syam, Dr. B.P. Todi.
He's not there. Which is not? None appears for the petitioner. And the last date for that 2 weeks' time was agreed. Oh, 2 weeks' time was agreed for rejoinder. In interest of justice, this is after 2 weeks, 3 weeks, yes.
Item number 6.
Please, Lordship. Let's have a request for some more. Someone to file my affidavit, Lordship.
Contempt, Mr. Karanam.
Lordship.
Are you in contempt?
No, Lordship.
Yes.
No, Lordship.
No.
Lordship, as per the reading of the judgment, Lordship, there's no willful disobedience of the Honorable Court's judgment, Lordship.
Which matter is this? Which, what was the matter about?
Oh, Lordship, this is in regards to regularization of
How many questions are there?
6 of them. Lord. The order was passed 1 year back. Exactly 1 year back.
There's no time frame given by Mr. Nagri.
Yes, my lord.
It's given.
Not
No,
given, my lord. But I've come after 11 months, my lord.
You file your affidavit.
Well,
yes, sir. Mr. H. Kalalang led it counsel for the respondent's pre-response allowed.
Lordship, for the 2 weeks' time, Lordship.
2 weeks' time. Okay, for a 2 weeks' time to file affidavit.
Item number 7.
Lordship,
Please, Lordship. Lordship, I have filed the affidavit on behalf of respondent 1, 2, and 3.
Only 3 respondents are there.
No, my lord, who is the school managing committee? Managing committee has not been coming. Appearing, entering appearance on behalf of respondent number 4, Lordship.
You don't want to file affidavit?
So by second instruction, Lordship. I pray for 2 weeks' time, Lordship.
Mr. F. Pandey, Mr. H. Karmi submits on behalf of respondents 1, 2, and 3. The affidavit since been filed. Mr. F. Pandey, like Paramus, entered appeal on behalf of the respondent number 4. As such, service complete on respondents. Copy. Pre-response allowed. 2 weeks' time to file affidavit if necessary. List thereafter also.
Item number 8.
I'm appearing for the respondents, my lord.
Praying for some more time, my lord.
Yes, Mr. Pandey.
Yes, my lord, the petitioners had
We'll
to
close,
file.
we'll close the rejoinder.
My lord,
Yes,
on the
ma'am.
last, my lord, only once, my lord. We have filed
Only
very
once?
simply. Yes. Yes.
Once the rejoinder business is, it's holding up all these cases which can be disposed
2
of.
weeks' time, my lord, will be done.
Yes.
Okay, for the 2 weeks, I'm spread. All of the rejoinder list thereafter also.
Right, my lord.
Item number 9.
Yes, Dr. Mojika.
Well, it's for affidavit, well, I'm praying for some more time.
The fresh matter.
Fresh matter. Today,
15-8.
2 dates have gone.
Yes. As prayed for the 3 weeks time granted to respond for affidavit. Just thereafter.
Item number 9.
That was 9. Next to 10.
Item number 10.
Entering appearance on behalf of respondent number 4, Lordship. Requires some time to file my affidavit.
What about number 6?
Lordship, I'm appearing on respondent number
Today
6.
only.
Today. I'll be filing the power today.
Mr. Roy Gopal Sundan is appearance on number 4, number 6. As such, It was complete on behalf of all the respondents. Are they free for how much time you are appearing for?
Respondent number 5, Lordship.
5 years. You have not filed affidavits yet.
Not yet finished,
Why?
Lordship.
Not yet finished drafting or not yet finished
Not yet finished on
filing?
that ground. There's so many translations.
Okay, that's how the last one was bus name also. You want to file affidavit also?
Just 3 weeks time.
Pray for and allow 3 weeks time to file affidavit. What about 1, 2, 3?
1, 2, 3, Lordship.
You won't file?
You won't file, Lordship.
Yes, sir. It's already recorded earlier.
No. Yes, Your Lordship.
Just after 3 weeks.
11.
Please, Lordship.
Yes.
Lordship, service of notice upon the respondent number 2 and 3, it's completed.
Today's no appearance.
Your Lordship, I am appearing for the respondent number 1, and we're the formal party here.
Okay. One number 4.
I'm appearing, Your Lordship, on behalf.
Oh. You file your affidavit?
I've already filed, Your Lordship.
I have received the affidavit filed by respondent number 4, Your Lordship. I have
2 and 3 is Bar Council of India.
Yes.
Why don't you contact them, Mrs. Sinkram? You contact the executive deputy someone about the to alert them about the penalty of this case. What are not necessary parties?
Your Lordship,
Are necessary parties for disposal of matter 2 and 3.
2 and 3, Lordship. If they are not appearing, we'll go at
No, are they necessary or not?
Yes, Your Lordship, they are necessary.
Though notice has been served upon response 2 and 3, no appearance made on the behalf today also. Next paragraph. On behalf of number 4, it's submitted that affidavits have been filed. You want to file a joint affidavit by 4? Number 4.
Lordship, will
Yes
file.
or no?
Yes, Lordship.
Mr. Yaru Pri is allowed to file. Rejoinder to affidavit filed by number 4. Stop. Next paragraph. This is matter after 2 weeks. It's expected the next date, response 2 and 3, who are necessary parties shall make their appearance. You just inform them. I'll inform just of the record. Yes.
12. Clear, Lordship.
Lordship, in this case, we'll be appearing for all the respondents, Your Lordship. And we pray for another 2 weeks' time, Lordship, to file a...
What's the matter about?
This is a non-payment.
Regarding payment.
Regarding payment, Your Lordship.
Payment of?
Final bill or contract.
MS Yangi and EAG paying for what is the place funds allowed 2 weeks for the time to file affidavit.
Lordship, this number 12 to 15 is the same, Lordship.
12 to 15.
12 to 15, same order.
You are paying in all the cases.
All the cases, Your Lordship.
Deep privilege, my lord.
16.
Please, Your Lordship. Lordship, as per the last order, we are supposed to do a hearing on our miscase.
Hearing
on our miscase, Your Lordship. But today morning only you have received the affidavit from
We have
respondent.
filed our affidavit, my lord. We
Good
have given
morning.
10 days time. We have filed it today, my lord.
We haven't go through, Your Lordship, the affidavit.
When do you
Kindly
want
grant
it?
us
Then
1 week
Rahman?
time, Your Lordship.
1 week's time. MS M. Raman submits that as they have just received a copy of the affidavit. She may be allowed some time to go through the same. Yes. It's a matter of 1 week for the orders.
Much obliged, Your Lordship.
17.
Yeah, please, Lordship. Lordship, this is the analogous matter with the item number 16, Lordship.
Yes, what is it?
With regard to the vacant post of the head master, Lordship.
Same case just
Yes,
now?
Your
Analogous, Your
Lordship.
Lordship, yes.
Your Lordship, by the order.
Who are you?
Lordship, I'm one of the teacher, Lordship.
And the only one was who?
She's also a teacher.
One of the teachers.
Listed together?
Yes, Your Lordship. There's a order on 3rd September.
Yes. This is matter along with.
Your Lordship,
Notice me.
I may be allowed to serve the notice to the council since they are appearing for the parties.
Yes.
Notice.
Which one? To which respondent?
Respondent 4, Lordship, respondent 9 and 10. In the previous matter, respondent 10 is the petitioner.
Okay. If they accept, how they'll accept notice?
May I please, your lordship, notice was not on last occasion, notice was not issued. Only thing is that both the matter will be heard together. So,
Mr. Court, Senate Counsel of Petitioner has apprised this court that notice, no order for issuance of notice to respondent 9 and 10 has yet been passed. So accordingly, that notice issued to respondents 9 and 10. It is further prayed that 9 and 10. If they accept, yes, as the matter is connected to WPC number 283/2024, it's the same together on the next day. Observe them, if they accept.
Hearing, item 18.
Please, Your Lordship. Your Lordship, in this matter, we are supposed to receive some instruction with regards to the material produced by the state respondent, Your Lordship. And we have received instruction, Your Lordship. The written statement was filed by us, Your Lordship.
Written statement was filed by?
By us, Your Lordship.
Where?
Your Lordship, this is here we are agreed with the impugned order whereby new members was approved, Your Lordship, who were neither were approved, Your Lordship, who were neither the member or the shareholders of the society, Your Lordship. This is regarding the society.
Yes. Then he said without membership they were voting.
Yes, Your Lordship.
Yeah, what instructions do you want?
Your Lordship, the material that the state respondent they produced last time, Your Lordship, here the written statement, it was filed by us, Your Lordship.
Before the registrar?
Yes, Your Lordship.
Yes. We filed an objection before the Chief Secretary.
That
a complaint was filed against regarding the composition of the new management committee of the Sintung to the Chief Secretary. The Chief Secretary has, from their office, a report has been submitted. But the report, Your Lordship, you wanted to see as to who had signed that report. So, Your Lordship, we have got the record showing that we have already placed it on the last date, Your Lordship, that the report...
Report signed by whom? Written statement filed by whom? This was filed by?
I don't know what was filed.
Yes, yeah.
That is there, Your Lordship, written statement filed by them. And then an inquiry was conducted by the Chief Secretary's office, and the report was submitted through their office only, Your Lordship. The report has been signed by the Registrar of Societies.
It was issued by the Registrar of Society, Your Lordship, not the Chief. Yes, Your Lordship. That is a report. Yes, we came to know.
Okay.
Yes, Your Lordship.
MSA Kashina.
This annexure
submits that
I think we have
the
given
instructions submitted by the London EAG or to the documents submitted by the London EAG. Still awaited.
Your Lordship, we have filed a representation to the Chief Secretary, but till date no action has been taken, Your Lordship.
That is not correct, Your Lordship. We have submitted that.
Your Lordship,
this on the last date.
You don't have a copy of this?
Your Lordship,
in the affidavit itself, we have stated that this complaint has been disposed of on 30th of November, Your Lordship. And this, because it was not signed, Your Lordship wanted to know as to who had signed this report. Now, through the office note, it has gone, and the Registrar of Societies conducted the inquiry and submitted this inquiry report. This is the next 11 2-hour affidavit, Your Lordship.
Your Lordship, on the last occasion, has asked us whether we have approached a higher authority, and we have approached the Chief Secretary, Your Lordship. So this this report was given by the Registrar General, Your Lordship, not the Chief Secretary.
So that if you file the representation before Chief Secretary, then he has given it to the Registrar for what
conducting an inquiry, Your Lordship.
Yes. And that's then disposed and not on the challenge here.
No, that is not.
We came to know only after they have produced, Your Lordship.
Then to challenge it also. Welcome to MSA.
This is the next 11 to our.
We will not see anything. Please for the one week's time. So instructions.
2 weeks, Your Lordship.
2 days.
2 weeks.
Or 2 weeks.
Yes.
Further instructions.
Much obliged.
19.
May it please your Lordship. Lordship, the respondent number 6, respondent same has filed till date, they filed 3 miscellaneous applications. The most recent one, Lordship, is miscellaneous application number 164 of 2024. We've received this last Friday, Lordship, on the 6th of this month.
What?
Lordship, the subject matter in these miscellaneous applications are very similar. We have filed our objections to the previous 2. If required, Lordship will file our objections to this as well, Lordship.
The Lordship, this is the customary issue that.
No, see, Mr. Mahanta, what has happened here is that there's been very twisted kind of.
Yes, yes.
You see,
very
unfortunate things have happened.
I understand.
Now, when the matter had come for this court consideration of the customary office that you occupy and the need, that since you were maintaining the road, so allowed that you collect a toll of 200 rupees on the road to meet expenses and to maintain the road. Now, what happened was that after the order was passed, then what happened on the ground is totally different. The thing is that there was a double charge, and then the road is not maintained. A small amount given to contractor only to maintain the road. And when the inquiry was conducted, and it transpired that certain people were responsible for.
In fact, it's very unfortunate. It's very unfortunate.
And so the court has to take action on those.
Yes. No, now the problem is the HEMA is suffering. What happened?
Suffering because
because of
people were supposed to advise the HEMA, otherwise.
That part, of course.
Suffering maybe has been self-inflicted.
Now, neither they could have any fund to maintain the roads, all these things. Therefore,
they had enough. They had a lot of funds. And if
so
they had fun with the funds, what can we do?
No, at least your Lordship, that what
we'll consider it, since it seems time. We'll have it next week.
Next week, Your Lordship.
Yes.
Your Lordship.
Yes, a miss case application number 164/2024. This is an application that's number 6 to allow collection of customary toll as per earlier order date 13/4/2022 for an amount of vehicle stock. We should notice on the same. Where the state respondent?
Your Lordship, with regard to this new miscellaneous application, Your Lordship,
Section
it's the same as miss case number 96, Your Lordship.
of the old one.
Yes, Your Lordship, that had been filed previously, Your Lordship, in this
Did already
matter.
filed a reply to that.
Yes, Your Lordship. Your Lordship, in my submission, this miss case is not maintainable, Your Lordship, because it's still.
MSZE non-country
Miss case number 9.
government advocate submitted that the miss case is a repetition of miss case 96 and as such not maintainable. Stop. MS the Cruz for the respondent number.
For petitioner, Lordship.
Petitioner. I was also prayed that she be allowed 1 week's time to examine the same to file objection if any. In view of these submissions, this is a matter after 1 week positively for further consideration.
In fact, Your Lordship, right now I heard that it was disposed of earlier the same prayer.
No, Your Lordship, number 96.
I was missing.
Let them put a record. We'll deal with it, Mr.
Yes.
Samantha, piece by piece. Since you're here now, it'll be a bit clearer also.
I'll clear it. I'll
We need assistance also.
Yes.
Otherwise, you see, this is a very.
I understand.
Apart from the subject matter of the case,
yes,
whatever
no, that matter.
the right thing that happened.
Obviously, Your Lordship, that matter I have no comment on.
No, you have to go very unpleasant. So we have to, give it.
Only I am concerned now, present, what is the situation?
So we understand.
But I'm.
Just post in and put together hardship.
20.
As you much.
Yes, yes.
Your Lordship. There 100 hectare is.
Yes. Acres.
100 hectare.
100 hectares, yes.
Yes, Your Lordship. It was part hard in previous occasion, Your Lordship.
I don't remember anything. Your petitioner now has
Yes, my petitioner,
tarnished himself
writ petitioner already,
with a black brush. Yes.
yes, apologize,
So,
Your
first
Lordship.
you have to clear that black mark and then start arguing. Yes. But poor fellow, he says he just class 9 passed. So he's not aware in his excitement that he is championing the cause of people. That's why he went and spoke. We can understand, but he should not do it. Yes. Start. Yes.
Your Lordship, the respondent has pitched 100 hectares. And
now only one thing, just limit submissions to why do you say it is not permissible?
Not permissible because according to Supreme Court, Your Lordship,
let's start from there.
In all Demasa Hasso case, page 254, 276, the district council and the state government has been denuded from making any law regarding coal mining.
Where that? Let's see the. There's a book. You give us a book, Mr.
Yeah.
Sharma. Now, have you given list of books?
Yes, sir. I'll give.
You've given list of books to the court partner?
No, not yet.
You kindly give it.
Yeah.
It'll ease the matters.
No.
See, one thing you have to look at the scheme of the MMDR Act, plus, whatever law you're policing. Now, whether it's permissible for the state to, to prescribe this. Yes. 142.
142, page 142, paragraph
142.
Paragraph 142, page 254.
Yeah.
The power of the district council has been denuded from making law on coal mining. In the similar way, page 276, para 195. Point 12, that has been denoted. Yeah.
Where is the state has been denuded the power? The council can understand where the state.
State is 276. Page 276, para 195. Point, subparagraph 12.
My lord,
Yes.
kindly, my lord. Lordship, the Advocate General is supposed to argue, but he's having some network issues, Lordship. Maybe listen tomorrow, my lord. He's not getting to, it's not audible to his side, Lordship. With this Honorable Court's permission, Lordship.
Yes. He went to coming physically. He's stationed in Delhi permanently now. Till he just comes.
He'll be coming, Lordship, but the exact date and time we are not aware, Lordship.
Only till the new chief justice comes then.
Not aware, Lordship.
Yes. Sorry, Mr. Due to technical issues, as the Advocate General could not join the proceedings, but have been made on his behalf for. This is Monday. We have it on Wednesday then.
Yeah.
Much obliged,
Lordship will file the list of books.
File list of books and whatever, yes.
Yes.
And the petitioner also is permitted to file a list of books beforehand.
Yes. You'll...
And a copy to us.
Page 1.
Yeah.
Much obliged, Lordship.
Because this is council, yes, they don't have power. Under 57
State government also
but
has
only
been denuded.
only whether state government under subordinate legislation can do, like if
They
it can
have
become
been-
as such.
They have been denuded, sir.
They will
According
examine
to,
that.
yes.
Much obliged, Lord.
Yes. You see the synopsis, Dr. Modica? The first line synopsis. See, don't want this decision to be given also. As a seal decision. Yes.
My lord, here the petitioner challenges the BRO, which is the punishment, my lord. Punishment awarded.
BRO is battalion routine.
Battalion routine order, my lord.
On what ground is challenging it?
My lord, no inquiry, nothing. And my lord, it's a no one can be the cause of its own cause, my lord. That's valid. I have filed a complaint on 9th August, my lord. And thereafter, my lord, they say that he himself has investigated. He himself investigated, but nothing on the record that any inquiry report. Nothing, they have not. And interestingly, a punishment was awarded for 14 days, my lord. All right. Redressment.
So you already undergone the RI.
My lord.
Then how can we take
My
it?
lord, that we wanted to declare that illegally. That punishment awarded to me was illegal.
You mean to say that you were taken into quarters guard without any order?
Any order, my lord. I will show on the record.
Mosika,
I will show on the
without written order, he can be taken and kept in quarter guard to suffer RI for 14 days?
14 days. Nothing on the record.
Before that, my lord, we have taken the plea that this honorable court will not have jurisdiction, my lord. The impugn order was issued from Punjab Mail.
Oh, it's Assam Rifle, my lord. It's Assam Rifle, my lord. The petitioner is from Assam Rifle. DGR is here, my lord.
That was the time you were on deputation.
My lord, it is the
NDRF.
The BRO, the NDRF, Assam Rifle, my lord. Here. NDRF also has a different BSF others, my lord. Assam Rifle.
What is the procedure?
My lord, procedure is the petition.
No, you and NDRF.
My lord.
The thing is that you go to NDRF, you are outside Assam Rifles. You go for training with them.
My lord.
Then,
but I am
posting with them.
I am subjected to Assam Rifle Act. The punishment.
How can you posted as first battalion at BSF?
My lord.
You are posted at BSF battalion number 1.
No, my lord. That's for the training, my lord. For the training.
Okay. You'll see the order.
My lord, order is that BRO publication, my lord, page, my lord, page 82, Annexus 7, my lord.
You encourage impersonation of who?
The allegation is that I have made a false allegation against the officers. But how that finding came, man?
You are challenging this after punishment has been inflicted. Only 14 days are not no other punishment. What other punishment was given?
My lord, 14 days RI also, my lord, rigorous imprisonment, my lord, that's illegal custody, illegal confinement, my lord, without any order of awarding punishment, my lord. And my lord,
affidavit, Dr. Mohan.
nothing is there, man.
You mean to say that no inquiry was held at all?
Nothing.
Without a written order, you were sent to rigorous imprisonment?
Yes, my lord. Entire affidavit is silent, my lord. Entire affidavit is silent, my lord.
On any order or not was there? Any
Yes,
proceeding was there?
In my affidavit, my lord, at page 23, your lordship, kindly.
1 second. No, it's pretty, one thing.
This is a repatriation order, man.
He was at page 2 from para C. Page 23, what do you say? Where's the dismissal order of Punjab High Court?
That was the, my lord,
Now, where's the order?
order is, my lord, it's, I have a next, my lord. It is at page
26 of the affidavit.
The affidavit.
Well,
page 50A of the writ petition.
That's all. All no res judicata.
No, man.
Yes.
That was the habeas corpus petition, my lord. That was a habeas corpus petition. Not that.
Where did it say habeas corpus?
My lord, it's
CRWP.
CRWP, my lord. It's a. My lord, it's page 47, para 2, my lord. This was filed by the wife, my lord, petitioner's wife, my lord. 47.
Page 47.
My lord.
Para 2.
Para 2. My lord, first paragraph. Her husband married, my lord, that the present petition of the petitioner has.
So that time he was in Punjab.
In Punjab, my lord. And he was kept in captivity. The wife filed a petition, man. Whereabouts?
This is affidavit file. Yes.
But the proceedings happened in Punjab, my lord.
Hmm.
Potentage RI was in
It looks
Punjab.
like that. That's what this court saying, that where's the orders? They're going to see where the order was passed. It's Punjab. Because whatever happens, it was the recruitment rally held where?
My lord, in the Assam Rifle, my lord.
My lord, he went on deputation to NDRF, my lord. In the year 2019, he went on deputation to NDRF, my lord. And the incident happened around 2022, while he was on deputation to NDRF, my lord. Only thing is that because he was on the rolls of Assam Rifle, my lord, the proceedings were initiated under the Assam Rifle.
That's why you want to see where's the proceedings, where's the order, who's the author of the of the proceedings and the order. That's all.
Yes, ma'am.
Without Assam Rifles.
Yes, ma'am. Still
do whatever he. See, even the repatriation was on disciplinary grounds. Page 23.
That is repatriated order, my lord. I have been sent back to the Assam Rifle.
They've asked to take strict action against you. So you're a habitual offender, I see. Where's the order, Mr. Mozika? Where is it here? You're sentenced to
14 days.
14 days.
I have not filed affidavit on behalf of NDRF, my lord. Though they are as a
party.
Yes, ma'am.
They are made a party, my lord.
We have to have that, because if there's no order, that means what were the proceedings adopted?
My lord,
under what? Under Assam Rifles Act? Under what?
Under Assam Rifles Act, my lord, that lordship will kindly see, my lord.
Then where's the order?
At page 23A, my lord, it's a typed copy. In fact, this is a typed copy of page 23 itself, my lord. In para 2, it says, my lord, he was verbally warned several times as well as in written also to improve his behavior and attitude, but individual failed to do so.
Right, now come to para 4. Read para 4 kindly.
In view of the above, individual is found unsuitable for NDRF rescuer duties and has a negative impact on overall discipline of the troops. He is perpetual offender, indisciplined soldier, instigator, makes groupism and spreads superfluous rumors among the TPs through WhatsApp group and mobile call recordings. It is recommended that the individual be kept under strict vigilance and close observation to monitor his activities, and strict disciplinary action be initiated against him for the indiscipline, unlawful activities. Otherwise, individual may affect on the unity of the.
This was after it already undergone that imprisonment. And even though he was found to be, whatever it is, he might be any kind of person, doesn't matter. But the thing is that where is the proceeding which caused him to be?
Well, the proceedings are not enclosed, but in para 2 we mentioned, my lord.
No, mentioning is different, but then where the documents to show that there was a proceeding, then he was found,
My lord, charge sheet is we have annexed, my lord.
That is tentative charge sheet.
Tentative charge sheet. But that is the charge sheet, my lord. The word tentative is used, but that is the charge sheet, my lord.
Then where's the order? Of course, you had to take action, but the thing is that should be due process.
Page 21 is the record of proceedings, my lord.
He said in Punjab.
In Punjab, my lord. 13 NDRF is in Punjab.
14 September 22.
My lord.
Strange matter, because otherwise, the counsel is quite, signature accused not here also. He declined to sign also. Yes, Mr. Jha, what do you see this 21?
My lord.
Declined to sign,
My lord.
declined to examine if this proceedings are
Even,
correct.
even assuming, my lord.
Where's the order?
My lord, even assuming I have declined to sign.
Where's the order?
That's nothing on the record.
That's the only thing you put.
Yes, my lord. Even the petitioner wants that without any inquiry, without any order.
No, inquiry might have been there. Where's the order? It's not possible that Ramozia there's no order.
And at page 81 of the writ petition, my lord.
Is the order?
That was the BRO published, my lord.
'13 Battalion, 14 September 22, 14 days RI in unit quarter guard. Order dated 18/2/23.
This is the order. It's the first time this court is not aware. I mean,
my lord,
we have to
educate
this court. So is this the order?
No, my lord. What happened, my lord?
There's no reasoning that based on inquiry so and so is found to have violated so and so whatever and so hereby sentenced to.
Definitely, that's it is the procedure, my lord, as per the Assam Rifle Act and rules, my lord. This is the after the publication of the, my lord.
But my lord, the fact remains, my lord.
Because you see, why can it be in order? Because the punishment is already over. He said 7 September to 14 September. Or to 14, whatever. Did the punishment 14? Punishment awarded 14 days. I don't understand the order. You sure there's no order at all?
Yes, ma'am. I have filed a rejoinder to that effect.
But even then, if we said the order, you already undergone the risk imprisonment.
My lord, my lord, that's why my prayer is.
His prayer is alternative prayer is for 2 crore rupees compensation.
Compensation, my lord.
Okay, you take only 1% of that.
Even 1% is 2 lakh. 2 crore.
Definitely, my lord. For a day also, I have been inside the prison, my lord. So, malified action.
See, there's not that. It's just smoke around fire. Is that you were charged, you were given a tentative charge sheet. You, as per the proceedings, you refuse to sign. You decline cross-examination. Only missing is that there's no order proceedings.
in my lord, that's it is the and interesting, my lord. During the prison, my lord, the petitioner was on a medication, but the warning letter was issued in the prison itself. I have annexed that, my lord.
That's subsequent because you're unfit, you're instigating, you're making WhatsApp groups, you're demoralizing the troops.
No, that's a prior.
So that even they have contemplated that further action should be taken against you. The only thing that goes
I'll try to get the
only thing that
the order, my
lord. Order generated.
I'll try to get it, my lord, and file an additional affidavit. But let's say it's better if he withdraws and files in Punjab.
No, my lord.
In any case, my lord.
No. Why double?
When on deputation, my lord.
My lord, it's
only thing that charge under Assam Rifle Act because
no. This, I mean, the record of proceedings shows that. See, it is the Assam Rifles that you see. It's by Assam Rifles under Rule 47. But it's okay, fine. We will dispense with certain provisions, calling hearing witnesses, so and so. Why didn't sign the this sheet?
My lord, that time the petition, even I am not signed, my lord.
It's not self-incriminating. It's recorded accused declined to sign presence of following independent witnesses. But vote on the NDRF only. You're right. Even this order, although under proceedings under Assam 47, was conducted by who's the commandant 13th Battalion NDRF?
Well,
He
NDRF
is also Assam Rifle, my lord.
it cannot be, my lord. NDRF, National Disaster Relief Force, is a separate force, my lord.
On the petition they go there.
So they go on deputation from maybe Assam Rifle, from state police also they go, my lord. So when they are on deputation, my lord, they can only be still be disciplinary proceeded against under their current act.
Get instructions from this from the 13th Battalion NDRF only. Mr. Jha,
My lord.
the only thing you're saying is there's no tangible order. Then they just send it for fun out there, I think.
No, my lord.
Days.
No, my lord.
Yes.
Even the Supreme Court judgment says that if the inquiry vitiates, if any proceeding,
yes, it can be vitiated. But in your case, what has happened? There was a proceeding, right? You declined to sign the proceeding book, whatever. You declined to examine witnesses. They put you in the RI for 2 weeks.
My lord.
Now RI 2, there's no order for RI 2 weeks. You only served it. How do you restore your liberty?
My lord. If I have written, if I
just your prayer.
I have made an allegation.
Okay, we can set aside the finding that you should not have been, should not have. So what is your relief then? You want 2 crores? Illegal confinement. Take down. In the course of the proceeding, in the course of the hearing, Court and Mozika, though has referred to proceedings dated 14 September 22, next as Annexure R2, the affidavit of the respondents number 1 to 6. However, the question of the order that was generated thereafter, whereby the petitioner was sentenced to undergo 14 days rigorous imprisonment, praised that he will have some time to seek instructions and obtain the same. Very strange case. There must be an order. There must be.
There must be an order.
Just after 2 weeks, yeah. There must be.
23.
Not possible. Yes.
My lord, this
what additional affidavit is this?
My lord?
What additional affidavit is this filed today?
Yes, we have filed. No, on Friday we have filed.
Who's up for power grid?
Lordship, I am representing Power Grid, respondent 3, 4, and 5.
Yes.
Lordship, we have seen that affidavit. Lordship, however, it will not have any material bearing to the case in view of the law which I also attempted to discuss on the previous date, Lordship. The Telegraph Act, under which we have been executing the work. Part
I hear you clearly, Mr. Khera. Yes. Yes. What do you have to see the additional affidavit? Yes. Yes. We're not clear. Yes, please. Submit.
Lordship, the additional affidavit will not have any bearing to the case. Their main writ that they have filed is for enhancement of compensation, and A, and B, to recognize them as the rightful person to whom the compensatory amount should be paid. Now, Lordship, there are 3 tower locations which are there, and there is all 3 tower locations have a different set of facts, and there are disputed question of facts, Lordship. And Lordship, if we see it in light of section 16, particularly subsection 3, 4, and 5 of the Telegraph Act, Lordship, which we are empowered under when we are executing the work under 164 of the Electricity Act, Lordship. So it says that any disputed arising with regards to the sufficiency of compensation or with regards to the person who's claiming, Lordship, it is the district judge who is the sole authority to decide upon it. So they will have to approach the district judge with an appropriate application, whether they want an enhancement in the compensation or want to declare that they are the personnel who are rightful to receive the compensation. As far as the amount goes, Lordship, there is no dispute to it. We, as the executing agency, we have already deposited the sum of money with the Deputy Commissioner East Khasi Hill.
Right. We've seen that last time. Yes, Mr. I want to ask Mr. Sana, why you filed the additional affidavit?
My lord, I filed it.
My lord,
I have got it.
What you seek to derive from this to help your case?
My lord, I may be allowed to submit, my lord. My lord, here, my lord, we have filed the additional affidavit producing 2 documents, my lord. Here, my lord, what happened? When the project was been initiated by the power grid for installation of the corridor and line, my lord, there was initially the first letter was given to the Hima Moklam to us, my lord, stating that they are willing to install the project that is they call Northeastern Power Project, my lord. In that project, we were first, the petitioner was contacted, petitioner's office was contacted, and thereafter, in regard to the negotiation of payment, in regard to the installation, in regard to the land, in everything, my lord, was communicated to us through us. Even several meetings were held. In those meetings, the subject matter was discussed, and the possible results were also being taken. Decision also was taken, my lord. Suddenly, what happened, my lord, when in regard to what Mr. Khera has submitted, we are not on that point exclusively. Our point is this, my lord. With the power grid, with the office of the power grid, there was a resolution that a rate of rupees 1,400 per square feet will be allotted. Thereafter, my lord, on that meeting, on several meetings, it was decided that the Hima Moklam will take the necessary steps to give the NOC to the power grid for the purpose of installation and to provide the actual rate of the land. Up to that level, my lord, there are several documents I have to read, my lord. In this time of submitting, several documents are there showing that up to this level, that discussions were being taken up. Now, immediately after that, my lord, my authority and my presence, my communication have been stopped by respondents. I was never called for, and suddenly
for the meeting,
for any further meeting, even for the purpose of NOC. When I have given some NOCs, thereafter, for the purpose of execution of all those decisions and all, where I was not consulted, I was not informed, and everything done without my knowledge. And respondent number 13, who happened to be the headman of one Krishnam, Manga Krishnam, he intervened and he negotiated behind the back, my lord, without giving any information, neither from the state respondents, nor the power grid respondent, nor the private respondent, my lord. And a rate has been decided of 1,000. Now the value of the land, as per the rule, my lord, compensation has to be given 100% of the value of the land plus 15% for corridor installation. Now the rate of the value of the land was provided by the district council at the rate of 1,400. Accordingly, the rate was discussed. Now our contention is this, my lord: why our authority has not been recognized, and why we were not consulted for further. Had the meeting of discussion about the reduce of the rate or uniform rate, we would have taken a good part. Either we could have substantiated the point, our point, or we could have considered the rate provided by the authority.
Not now. Can a writ court now direct that? No, without, no, we can't go into those exactly. Whether the Mongap Klitschnong is the appropriate authority to plan an NOC, or is Hima Moplang to deal with only. So whether it belongs to the village or the land belongs to the Hima, that is a question.
That question, my lord, is very what we understand is a very dispute in civil dispute.
Yes, so that now can this court order that, okay, fine, pay the compensation. Now the power grids deposited the money with the deputy commissioner, right?
Yes, ma'am.
Now can you release the money to you? We can't do that.
No,
we can't do it.
No,
now we can't. You can't ask for a writ where you seek enforcement of your rights to, to this court to enforce your rights as to the ownership over that land. Now, how sitting writ court, maybe sitting in a different dispensation, fine, but writ court, can we do that?
Well, we are not disputing about the entitled law. We are not disputing that.
You want that you should receive the compensation. That's all. Right? Because you see that land with the jurisdiction of Hima.
Yes, my lord.
While the Kleshnaw says no, they've given their own NOC. And your grievance is that initially when the power grid, they were negotiating with you, the rate was fixed, everything was fine. One fine day, they just shut you out and they took NOC from them, and that's the thing. But now the fact that remains is that the money is still with the deputy commissioner. So then if as per in the Telegraph Act, you have to make your claim before the let him decide.
No, the rate about the rate, my lord.
No, I mean, like this dispute that you have.
The dispute, my lord, that decision, all those decisions were taken without by consultation, my lord.
Exactly. So no, we're not saying that it has done, but the thing is that now who was entitled to the compensation?
I think he is the petitioner of the land, my lord.
Yes, we're not going to go into that. Here's Mr. Sen. How do you solve their problem?
Under the Telegraph Act, there is
a court, we can't do it.
Precisely.
Then
the district judge will go into the question of title. If your lordships kindly have the Indian Telegraph Act.
No, it's all right. I think it's here somewhere. Yes.
So lordships will see section 16.
Yes.
Exercise of powers conferred by section 10 in disputes as to compensation in case of property other than that of local authority. Kindly see subsection 3 and 4. If any dispute arises concerning the sufficiency of the compensation to be paid under section 10 clause D, it shall, on application for the purpose, my lord.
It come under 4.
Yes, my lord. 16.3 and 16.4, one is with regard to sufficiency and the other is in respect of who it should be paid to. So their grievances with regard to 4 tracts of land. In respect of 2 tracts of land, compensation has been released to the private respondent number 13. And insofar as the sufficiency of compensation is concerned, their grievances with regard to 2 tracts of land. There the compensation is yet to be released.
Sufficiency or who to receive it?
Both millets. So in respect of 2, it has already been transferred to...
We have no quarrel the other 2.
No millets. That's what I understand from the prayer.
If I may, Lordship.
Yes, Mr. Kera.
Lordship, subsection 3 deals with the sufficiency of compensation.
Yes, yes.
That would entail when a particular one party would have come and said that the compensation amount awarded is not sufficient.
Right.
Lordship, here the issue of sufficiency also is there, but under subsection 4, there are 2 parties who are disputing that I am the rightful recipient of the compensatory amount. So they will have to go under 3 and 4 Lordship.
No, right. No, we understand. We understand that. Yes, that's what Mr. Sen was saying. When you.
And if Lordship,
one thing I want to know is whether they ask what remedy do they want is if they feel that wrongful payment has been done to the authority. What is the method to challenge
recover?
That?
Lordship,
recover. It comes under what?
Lordship,
under 4, my lord.
5.
Under 4. Can you see if any dispute arises as to the persons entitled to receive compensation?
Not entitled. You said in 2 tracts already been paid the amount.
Yes, my lord. So I understand Lordship's question. Where money has already been released, they'll have to file a civil suit establishing title. This goes beyond subsection
That will
4.
complicate the whole thing. It'll
Yes.
go into two parts altogether.
My lord.
Lordship, this
Okay,
issue is
the
also
amount
covered.
has not been released and this claim title, fine. The money is still the deputy commissioner. You go and place your case with the district judge, then they decide. But with regard to, you see, even for the other two tracks, you're entitled to, the money should have been paid to you. Correct?
Yes.
That is my lord, recently it has been paid to us. We have received it.
Which one?
That one stretch.
That is for a different stretch, my lord.
So we forget about those two stretches then.
Okay.
0405, one stretch.
We
my lord.
forget, then let's see where we said that. The first two stretches, we forget about it then.
Yes, my lord. Well, as per the, my lord, here, there is the Gazette of Meghalaya, my lord, which has been submitted by the Power Grid respondent in their affidavit nomination page 100, my lord.
Page
100, my lord.
Annex to 11.
My lord,
one second.
my lord, here compensation in the paragraph 1, my lord, paragraph 2, my lord, number 1. That compensation has to be determined at the rate of 100, my lord. 100% of the land value by the, this notification has come from the government of Meghalaya.
T4 and 5 power grid. Okay.
Yes.
Where's the two? Where's the in the Gazette? Where's the 4 strips of land?
Page 100, my lord.
Yes, you got page 100.
Yes, the government of Meghalaya is pleased to notify the following guidelines for payment of compensation towards damages that are stipulated in section 67 and 68 of the Electricity Act, read with section 10 and 16 of the Indian Telegraph Act, which will be in addition to the compensation toward normal crop and tree damages for right of way for transportation.
No, where did describe the land? You said it describes the land.
No, these are general guidelines.
Yes, it's a general guideline. Where
It's a general guideline,
the
madam.
court asking?
No.
They said there are 4 strips of land. 2 strips, one strip will pay to, one will pay to spot number 3.
No, my lord,
Where is that?
Well, that's in my affidavit.
It's in affidavit of the state.
Okay.
Kindly see the affidavit that we have filed on 29/2/24.
In page 3.
2, 7, 9, and 10. Yes.
In page 3, my lord.
1 second. Is that to be clear?
Lordship.
1. Yes.
The state's affidavit, my lord, at page 3. Page 3, subpara B. Kindly see there are 4 stretches mentioned here.
Yes.
AP 268 to AP 269, AP 269 to AP 270. In respect of these 2 stretches, the compensation has been released to the private respondent number 13. Roman 1 and Roman 2.
Okay.
So this has been released to the respondent number 13. Now AP,
But they said they got one of.
yes, my lord, the third one. AP 4 to AP 05.
Third one, my lord.
The third one.
That is to the petitioner.
Lordship.
And it's 2 to.
So what is outstanding is the 4th one. 265 to
What do you mean?
272. Yes.
Now who's applying for 13?
Your Lordship.
Anyway, you received these 2.
Yes, Your Lordship. A portion of 68, 69 has been returned to the rightful owner, Your Lordship.
Okay, fine. But you received these on behalf of what?
This,
Yes, sir.
Yes.
I have
You
got a
don't
report.
follow that anymore.
oh, that's also, my lord, because it has been received wrongfully, my lord, in the private account of the.
So AP 04 that you've received. Do they have a claim to AP 04 also?
No, Your Lordship.
To the 3rd stretch, no. Now only remains the 4th stretch to AP 265.
Yes, 265 to 272. Yes.
Your Lordship, the controversy would be, it's with AP 68, 269, 269, 270.
Yes, understood.
My Lord has posted a very pertinent question. What happens to the amount that has been already released to respondent number 13? How does this court deal with it? Kindly see their prayer. I don't think the prayer has been sufficiently drafted to meet that situation. It's at page 29 of their writ petition.
I'm trying to condense the dispute to make it manageable, because otherwise, here's the prayer. What did he say?
Prayer is at page 29 of their writ petition.
Yes.
I don't see any prayer for refund of the money from the private respondent number 13. So kindly see the first prayer at A, pass an order directing the respondent to fix the rate of compensation at 1400 per square feet. Then B, pass an order directing the respondents to release the compensation amount in favor of the petitioner. Then C, pass an order enforcing the right of the petitioner and its HEMA to receive the compensation. This is again a matter to be decided by a civil court. D, pass an order directing the respondents to pay the compensation as per the provisions of the Indian Electricity Act. That is again directed against the state. Then E, pass an order directing the respondents to pay the adequate compensation towards the damages caused to the raid land in course of construction of the transmission line. And similarly other prayers. These are all directed against the state. Now the question is, what happens to the payment which has already been released to the respondent number 13?
Yes.
These prayers don't meet that situation. This would be best suited for a civil court to decide.
But even for the amount yet to be released, whether it's contesting A265-272,
yes,
they have to go under in the Telegraph Act.
Yes, my lord.
My lord, my condition is that that money which has been released to the respondent number 13 at the rate of 1,000 or rate of 800, my lord, that was not within my knowledge, because everything has to be routed through the approval from the Imam Muflang, my lord. That has not been, your lordship, that has not been done, my lord.
Mr. Nath, that's what on the bridge and your prayer correct does not cover that aspect. The only thing now we confine ourselves to AP 265 to AP 272. Okay.
Your lordship,
whatever rights you, whatever claims you have, Ms. Lindo, with regard to AP 04 to AP 05, you have claims against that also.
No, your lordship.
Oh, that's fine. Then
These are the only 2 towers, lordship, that passes through the village.
So now that means you have.
Your lordship, with respect to the submission made by learned friend saying that we have bypassed, lordship, but your lordship may kindly refer to.
We're not going to do that, Ms. Lindo. Fine, whatever is bypass or.
Yes, your lordship, but there has been clear instruction, your lordship, by the document that I have relied. Your lordship. No, your lordship, in the document relied by the petitioner.
In the affidavit, new affidavit?
No, your lordship, in the main writ petition.
What did he say?
At page 69. Lordship, may I read?
Yes.
Lordship, where the petitioner has issued a letter to the deputy manager. Lordship, with reference to subject cited above and your letter mentioned under reference, I am to inform you that this office has negotiated the matter with the concerned landowner as well as with the local headman of those areas and the Mongap Krishnong and Mongap Khachian. Lordship, there are 2 villages involved, Lordship, not just Mongap Krishnong, but it has been targeted only with respect to Mongap Krishnong. And your lordship, may I apprise that there are many villages of which through this tower is passing through. But only this village, Mongap Krishnong, has been targeted, your lordship.
Okay.
That a cousin land proposed to be acquired for erecting transmission line towers, read to say the land will refuse to part with their land. Lordship, they've already discussed with the respective landowner, your lordship. So there's nothing as such that would bypass any of the authority of the petitioner as he state. And however, your lordship, with respect to the affidavit, they have filed freshly, your lordship. This is kind of a direct personal vendetta against me, lordship, personal grudge. They're showing certain documents of which they are targeting me personally, lordship. However, I'm not the only village, lordship, where this tower is passing through. But there's been a personal target against me, lordship, over whatever allegations they have. So, your lordship, this is an abuse of the entire process against me. And moreover, your lordship, in respect of the summary of the case put up by the petitioner, basically there has been a stress of a differentiation of the land that he stated it's a right land.
Yes.
Your lordship, basically that is his purpose of approaching me for your lordship, that this is a right land and that he is entitled to all the whatever compensation.
Compensation, yes.
Yes, lordship. So, your lordship, in my affidavit that I have filed, I have relied on documents that this is not a right land, it is a regency land, your lordship. That has been clarified in my affidavit. And moreover, Your Lordship, one of the military also of the HIMA, Your Lordship, in one of the documents that I've relied, he has already certified my land as a vacancy land, Your Lordship, which is a personal and self-acquired land. So, Lordship, the entire claim even against me, Lordship, it's totally false. But, Your Lordship, to assist the court, I have brought in report the land documents of which I have relied. And one more document, Your Lordship, which I have relied is the letter which I have submitted before the state respondent, which is the collector, giving clarification of the entire claim and issue which the Lingdo has put against me, which is annexion number I, Your Lordship, at page 27.
Your cause?
Yes, Your Lordship. Your Lordship, prior to filing of
the Deputy Commissioner.
Yes, Your Lordship, I was dragged in before the Deputy
So what
Commissioner.
happened is proceeding with the Deputy Commissioner?
Your Lordship, I have filed whatever documents to clarify that this is a regency land and not a right land. So upon filing of this show cause, Your Lordship, then the matter was deemed to have been closed. So there's no any notice was issued to me upon filing of this show
Okay,
cause.
take down then.
My lord.
Both are okay.
I've got small
Yes, Mr.
submission in reply to the submission. My lord, it's a fact that there are so many villages are there. Those are having their private land also. But all have got the compensation. Also, the pending compensation is there. But all the landowners as well as the village members, they have taken no objection, approval from the Imam of Lang. But the respondent number 13 had issued all the NOCs bypassing without taking any of
You mean
approval.
to say that they paid some amount from Maplang to the village or no? The other villages you see who submitted the authority Hima Maplang, did you receive any amount from there?
From the village?
Yeah.
No, well,
the only thing you said.
Only the NOC has to be approved by the IMA.
Okay.
That was not done.
Right.
And also, my lord, in regard to the show cause, why the show cause was given, my lord? When an issue was raised by the Imam of Lang that illegally that money has been deposited in the private account of the customer 13.
Yes.
On that issue, Deputy Commissioner and other members have had a meeting. On that meeting, it has been decided that it was not done properly. Then the respondent number 13 was asked to submit the APR, all payment reports, as well as file the show cause.
Now all that will have to be thrashed open again.
No, Your Lordship, I have a small reply.
But the thing is that you say that you have no quarrel with that last stretch.
No, Your Lordship. Your Lordship, in my
If
affidavit,
they take it, you have no objection.
Your Lordship, that is the point I would like to apprise before Your Lordship.
Yeah.
Can page number 5 of my affidavit, Your Lordship.
Of your affidavit.
Yes.
So that's the only money revealing with the Deputy Commissioner.
Yes, Your Lordship, so far as the state is concerned.
Yes. Page 5.
Page number 5, Your Lordship, yes.
Okay. Yes.
Paragraph number 9, Your Lordship.
Yes.
Lordship, here the statement, Lordship, the document I have relied, Your Lordship, it's since the year 1987. This is a
See,
self-acquired.
we're not deciding title here.
Yes, Your Lordship, but apprising of the fact that the allegation has been put against me so strongly.
So, okay, you have a right to refute that. Now, the only thing is that now the dispute boiled down to, very simple thing. Now, they have grievance, you take it 2 stretches, correct? Which is, now, but they have not been.
Not correct, Your Lordship, for that reason.
Please listen.
Yes.
Now, number 3, they have taken it, you have no objection. Now, number 4, also, you see, you don't care if they take it, right?
It doesn't fall under my land, Your Lordship.
Then,
Your Lordship doesn't fall under.
4 comes under whom? That stretch.
No, that is different village, my lord.
Then where the other village out here before us?
That's what, Your Honor, I'm only one.
They are not in dispute, my lord.
Even not the entire village, but personally, I've been made a party, Your Lordship.
There's no dispute. If they don't claim the stretch 4, what is there to go to the
My lord,
judge for?
they have followed all the rules, they complied with the procedures, my lord.
Please listen. Please listen. We just try to help the court also.
Yes, my lord.
Now, from what we have, discussed, we both under the impression that there is a standing dispute with regard to two remaining steps between the HEMA and the SHNA, correct? As to who should get the compensation. Now, from what appears after hearing all of you, that the four stretches, two stretches, SHNA has taken. That money is gone.
Yes.
You want to recover it, you have to go by another method. Right. Number three, you have taken it. And they have no quarrel with that. Take it, that's your money. Number four now, the only strip that remains to be for the compensation made, that doesn't involve him also. Then what are we deciding here then?
No, this stress number 4 has been revealed by the affidavit of the state, my lord. We have not read anything about it.
Number four now, who's the person who's counterclaiming you, number four? Nobody.
No, there is no claim for
the issue, my lord. The entire writ petition has averments with regard to the release of money for the first two stretches, but the prayer is misconceived. That's what I was pointing out.
Exactly, my lord. For that you have to. Then if there's no dispute, what are we sitting here, lordship? You have alternate remedy. You can file if you want recovery. For far as Mr. Khera's clients are concerned, the money is there. The principal release it to the stretch number 4. You have no objection to that also.
No, stretch number 4 belong to the private persons, my lord.
You have no objection to that.
We don't have.
That's over.
That is not an issue also. We have issue.
We'll close this. We'll close this. Petition in
my lord,
3 lines.
My lord, we have issue. We have issue. Our contention is.
We'll
my lord,
3 lines, Mr. Kumar.
My lord, our contention is that despite several meetings with the respondents, my lord.
Understood. Yes. Only Mr. Miscellaneous, he's agreed with the personal allegations leveled against him. So that's it. That you can take it in another fighting range.
Yes, Your Lordship.
Not here.
That for sure will pursue, Your Lordship. But
Station number 3, my lord. Initially, it was in dispute. Station number 3.
But you have got the money in your pocket.
Now they have released, my lord. State.
And there is no dispute with regard to the quantum, as I understand.
Quantum?
On the quantum of this third stretch, there is no grievance.
Yes.
It is under discussion.
The petition has been brought before this court by the petitioner. Yeah, just questioning the manner of release of compensation and the fixation thereof with regard to the land needed for erection of towers by the respondent number 3, 4, and 5. What is the project called?
NERP SIP. NERP SIP, Lordship.
Northeastern Region Power System Improvement Project.
It's under the NERP SIP. Northeastern Region
Power System Improvement Project.
NERP SIP. NERP. Now, the next paragraph. The center of the issue in question appears to be the claim and counterclaim by the petitioner, who is the Lingdo of Imam Oplang, on behalf of the Oplang Lingdoship, and the respondent number 13, who is you're the Sardar headman.
the ex-headman.
The ex-headman of village Maungap Krishnam. So, the acquisition of the land was in 4 strips.
Lordship, Lordship, we don't acquire the land.
Yeah, there's no acquisition.
No.
Right
setting
of
up.
a user.
Only setting up.
It is what is it?
User. We acquire the right of a user only, Lordship.
Yes, right of way.
We only acquire the right of a user
Yes.
over the land.
Right of
We are not doing land
is right of usage or right of way?
Right of way, my lord.
right of way, but the right that we are taking up on the land is right of a user. We are using the land, Lordship,
Right, okay.
for right
No,
of way.
The center of the issue in question placed with the claim by the petitioner, placed in the of human return on behalf of the organization and the respondent of 30 who is the exact the position of the land was
with regard to the land to be used for erection of a tower, bracket, ROW right of way, or user right, close bracket, for which appropriate compensation was to be paid. In the next paragraph, in the course of proceedings, it has been seen that, or in the course of proceedings, it has been placed on affidavit that the construction, erection of transmission lines had been defined as in the 4 stretches as follows. One, AP 268, capital AP, to AP 269, then Roman 2, AP 269 to AP 270, then 3, AP 04 to AP 05, and 4, AP 265 to AP 272. Is also apprised to the court that the compensation amount for aforementioned stretches 1 and Roman 2 have already been released, to respond number 3. And for a stretch AP04 to AP05, the amount has been disbursed to the petitioner.
Your Lordship, may I? Lordship, in the affidavit of the respondent number 3, and in my affidavit, Your Lordship, we have brought up documents that AP 269 and to AP 270, Lordship, has been returned, compensation has been paid to the rightful owner. Has been reflected.
It's already been released, yes.
Lordship, but it's no longer in my possession, Your Lordship. This is AP 269 and AP 270.
Okay, we'll address that.
It's a submission, right?
Number 13. And 13, and as per submission, thereafter to the rightful owners, as far as AP 269 to AP 270 is concerned. And for 3, that is AP 04 to AP 05, the petitioner, the amount has been compulsory been disbursed to the petitioner. Stop. With only compensation that is left to be disbursed is with regard to AP 265 to AP 272, for which the parties, associate respondents, have submitted that there is no dispute with regard to the entitlement of rightful owners to the same.
My lord,
Yes.
my lord, this is in regard to the stretch.
Number 4.
4, my lord.
4, yes.
But 1, 2, we have
No, we just will come here, yes. To the same. Next paragraph. Mr. H.R. Nath, Learned Counsel for the petitioner, submitted that the grievance of the petitioner is with the fact that for stretches Roman 1, Roman 2, the initial negotiations and fixation of compensation was with the petitioner. However, at a later stage, on NOCs issued by the respondent number 13, the matter was settled with the said respondent number 13. So, though no prayer has been made in the writ petition for recovery, he submits that the writ petition is entitled to recover the same. So, next paragraph. Mr. S. Sen, on behalf of the respondent number
2, 7, 9, and 10, my lord.
2, 7, 9, and 10. 2, 7, 9, and 10. Submitted that any disputes that may arise with regard to the quantum or with regard to the claims to compensation is to be dealt with under the Indian Telegraph Act, for which provisions are available by way of section 16 as given as given in section 16. So he further submits that as the compensation for 1 and 2 has already been disbursed, so the writ petitioner, if still aggrieved, can avail of alternate remedy. So, he further submits that in view of the submissions of the petitions for number 13, that AP 265, there is no quarrel with AP with the entitlement of the rightful owners to the compensation for 4 bracket AP 572. Nothing remains consideration in this petition. So, Mr. S. Alindo appears for number 13, next paragraph, has submitted that the respondent number 13 has been victimized by the petitioner and has victimized the petitioner for reasons best known to it. And in fact, on receipt of the compensation amount, the respondent number 13 himself has handed over to the rightful owner. That's with regard to number 2.
Yes.
Yes. With regard to number 1?
Yes, no. With regard to number 1, Your Lordship, it's in my affidavit.
Number, what do you say?
Your Lordship,
you've taken the compensation.
No, Your Lordship, let me clarify.
No, please don't need to clarify. Just one question.
It's a huge plot of land, Your Lordship. It's a huge plot of land.
Who took the compensation number 1?
It's by the headman, as per the resolution.
Fine. No.
Your Lordship, it's a huge plot of land. It's an 8-acre land, so
fine.
The petition claiming just a portion of where the right of way and the highlight transmission is running through.
No. I'll get the real this.
Yes.
For reasons best known to it. And in fact, on receipt of the compensation, the compensation has been received by the rightful recipients. Stop. With regard to the, he also endorses the submission of the advocate with regard to number 4, that it is situated in the different village where there's one number 13 and the village have no claim over. Right?
Yes.
Then the council nothing to say.
We have nothing to say.
Yes.
11 and 12.
Mr. VGK Kanta, with his usual fairness, has submitted that the council has nothing to submit, as it appears to be a dispute between the Himar and the Chinau. Next paragraph. Upon hearing council with the parties. Yes, Mr. Devnath. Mr. Kera, sorry, Ms. N. Kera for respondent number 315 that has endorsed submissions made by Mrs. Sen and submits that from the part of the power grid respondents also, the compensation amounts are even deposited with the commissioner for disbursement. Stop. Mr. Devnath, nothing.
Sir, I am not having any role. It's a formal.
I don't have a file. No, what see?
I am the formal party.
Yes. Mr. Not being a formal party, I have no submissions to advance.
6 and 8 are also formal party.
Who?
6 and 8, my lord, it's corporation.
MSR only also being one party has no submissions to make stuff. Having heard the council of the parties, it appears that it appears it is correct that not having heard the council of parties, what can clearly be seen is that there is a standing dispute between the respondent, the petitioner, respondent number 13, who have raised his claims and counterclaims, who have raised their claims and counterclaims. So, with regard to jurisdiction and control or ownership over the land, and as to whether the same is re-right or recanty. So, this court sitting in jurisdiction cannot enter into the realm of disputed facts to decide title. So, on the aspect of recovery, though no prayer has been made in writ petition, the writ petitioner is at liberty to take whatever appropriate action is deemed necessary. So, as far as the remaining compensation is concerned, as there's no dispute as to the number 4, that's AP 265 to AP72, as submitted by the parties, and there's no dispute as to as submitted by the parties. Nothing remains for consideration before this court, and the petition is upon disposal.
Obliged, my lord.
24.
Obliged, my lord.
Lordship, on the last occasion, the petitioner was advised to take some steps.
Lordship, we have taken a step. All the parties they have already filed their respective affidavit. This is a cover case, Your Lordship, where on the last occasion in WPC number 42 of 2024, in the order dated 25/6/2024, Lordship has passed an order. This is very same case, Your Lordship.
Same person?
Yes, same person in the sense that they have produced a letter. Where in that letter, the order was passed on the basis of the order dated.
For
Lordship, that yes, for regularization. My name also is appeared, Lordship. I'm giving this. This is the order. And then this kindly have a letter, Lordship. The Lordship. It's the same case where my name also is appeared here, Lordship, in the here in the order dated the WPC number 42 of 2024 in order dated 25/06/2024. And the one person is not saying that serial number.
Allow the court to look at the
Lordship, I'm so sorry, Lordship.
You will allow the court to read also how do you explain?
Sorry, Lordship.
Number 24 is in
yes, number 24 is my name. It's my name. And then the
is still alive or
yes, another person, the Sri Nam Singh is in number 9. Where the why
24 is deceased.
It goes slow.
24 is deceased.
Yes, Lord.
Now Rumi Chandra Maharaj is the wife of Emmanuel Aring.
Yes, Emmanuel Aring. He's the deceased. I'm the wife of that deceased employee.
Relax.
Lordship.
When did he die?
His Lordship, he died in the, he was in died in Hardiside. He stayed here. I managed it in the also. He died on 25/08/2020. It is page 30. I have enclosed the my petition. Page 30, the death certificate. Death certificate issued by the competent authority.
What happened to the other case?
Other case, actually, he also was not regularized later on.
Nam Singh Marak, what happened?
Yes, yes, yes. Then
Regularized?
He was regularized.
When?
On the basis of the letter issued by 11/10.
No, when was he regularized?
No, regularized Lordship, the Lordship, he has passed this in the order dated 25.
So no, has been regularized or still yet to be regularized? Or in the process of?
Is under process, because on the basis of this one, he's under process. Now, the time frame was given for 3 months to complete the whole process, because as per the order of 25/06. This is the cover case.
Same
case.
But my lord, this has to be placed before the cabinet lordship.
This is when? 23?
Yes, the same letter they have included. In the same letter, my name also is there.
Already working there. The thing is that now 23 letter, 11 October 23.
Yes.
Only that they say that the proposition of this is under
Examination, lordship.
Yes.
Lordship.
So the thing is that let the examine it entitled, there will be delegate organization.
My lord.
Finished.
Yes.
Yes.
Yes, Lordship.
And even the order says like that.
Yes. Yes, Lordship.
Order says what?
Order says that this is entitled.
See, look, but in the view, the matter is special matter of regulation, considered regulation, ad hoc employee should be complete. Is it considered?
Lordship.
If you are entitled, yes. Not entitled, too bad.
And we have placed the same in our affidavit lordship at paragraph 8.
Yes, they are also saying that it is the process. They are saying that he is a
No,
temporary.
that's not what we said. Just wait.
Right. They'll consider. Doesn't mean that even regularized.
Lordship. It still has to be examined, my lord.
Yeah.
Yes.
Yes, take down the petitioner with the petitioner before this court is the wife of one late Emmanuel Aring, who was initially appointed as bookkeeper in the office of the Assistant Agriculture Engineer, MECH, East Garo Hills, on 27/2/1997. The repetitious husband, however, expired on
the
25/8/2020, lordship.
while still in service.
Yes, Lordship.
25/8/2020.
2020, lordship.
You were still in service, correct?
Yes, yes, you are still in.
Yes, was still in service. Thereafter, did you ask for pension for the office?
Yes.
Let's see this letter date 28, page 28, and number 4.
Yes.
Yeah. So, however, on the claim of the petitioner to earn pension and other terminal benefits of her deceased husband, it was indicated by communication dated 2nd 2/3/2023 that a proposal for regularization of the service of the retired incumbent had been forwarded by a letter dated 10/4/2013, but the services were yet to be regularized. Next, Mr. P.T. Sama submits that the writ petitioner, the writ petitioner's husband, in fact, is similarly placed with a set of other employees for which the proposal for regularization of the ad hoc service is still under examination. A copy of a letter dated 11 October 2023 showing this fact has been produced, where it is seen that the name of the petitioner's husband is at number 24. He further submits that this court in WPC number 42 of 2024 by order dated 25/6/2024 on the same circumstances directed the respondents concerned to expedite the consideration for regularization. He prays that the same consideration be allowed to the petitioners, to the petitioner's husband. Stop. Ms. N.G. Shilla, learned senior government advocate, on behalf of the respondent, has submitted that regularization, it is not that the earlier writ petitioner, the earlier petition, in the other petition, or the deceased husband or petitioner in this petition are entitled to regularization automatically, but that the same is subject to examination as to whether they're entitled to the same. So, accordingly, in view of submissions, it is directed that as the proposal for regularization of the ad hoc service of the writ petitioner, their husband still under consideration, expected that the same be completed expeditiously, preferably in a period of 3 months from today. Matter stands closed.
Lordship. Much obliged, Lordship.
Give your respect.
28.
My lord, this is a matter more or less identical with item number 23. Just now my lordship has disposed of the matter, lordship. Here, lordship, there is a dispute. Here, lordship, what happened?
Dispute?
Here,
Where the other side?
Yeah.
My lord, 2016 lordship, they have issued notice to the petitioner that they are going to install a tower in my land, lordship. Then from 2016 to 2024 lordship, 21 lordship, I have raised some objection for installation, saying that unless reasonable compensation is paid for the land as well as the tree, so I will not allow the installation, lordship. After that, inquiry was conducted. In 2022 lordship, in 2022, that Nukma raised a claim saying that no, this is an Akhin land, this land does not belong to the petitioner. So in 2022, then lordship, I filed RTI. RTI report says that we did not, the DC revenue says that no, what we had only assessed, that we did not make any payment. The responsibility with regard to the payment to the landowner lies with the power grid, Assam Power Grid. Now, yesterday, while going through the affidavit lordship from the state respondent as well as the power grid lordship, it could be discerned that Nukma is a necessary party lordship. I'll file necessary application to implicate the Nukma lordship. His presence is very much important, lordship.
Then why don't you just withdraw and file before the deputy commissioner?
My lord, why now in the state respondent is saying that we have paid the compensation. Now,
Yes, sir.
now if it is paid, lordship, now remedy will be, my lord, if there is a dispute as per the land
As per in the Telegraph Act, you have to go to the...
Yes, lordship. Now, if money has been paid, then I have to initiate recovery proceeding, lordship.
Yes.
Now, even the power grid also, they are not saying that they say that now we have deposited the amount into the account of the DC revenue. DC revenue. Now I have.
See, for them, they have no. For them, the only thing is that they need that land. They've given the money. You give it to the deputy commissioner. He will disburse it. That the headache over. For them, they don't need to construct the tower. But that's all.
To Lordship will find that affidavit of the State Lordship.
But before that, Your Lordship, I beg to submit that Your Lordship.
what-
Inquiry was conducted regarding the land.
So we're not going to go to that. Yes.
What I am praying, Lordship, let Nokma come because he will ascertain whether.
Why will Nokma come? It now will take another year for you.
Civil dispute, Your
No,
Lordship.
Lordship,
matter.
now Lordship will kindly appreciate one thing.
Doesn't matter if your case was delayed.
Now, if
You're a
the-
petitioner, you want to get delayed, doesn't matter.
no problem, Lordship. At least,
No
at
problem,
least-
fine.
Yes, I'll file necessary application.
Yes, Mr. In the course of proceedings, Mr. S.A. Sheikh submits that after examining the matter in detail, it appears that the Nokma, which aking is this?
That Wada Kogiri Aking, Lordship.
Oh?
Wada Kogiri Aking.
Give the spelling.
What agree, WA?
Oh, Lordship.
WADAGO AGRE. What Dakogri?
Yes. Yes.
West Garvin.
Which part? West Garvin.
West Garvin.
West Garvin.
We can write Lordship Wada Kogiri Aking, Raspur, West Garvin.
Rajpur.
Raspur, West Garvin.
West Garvin is a necessary party. It pays allowed to impede to file an appropriate application seeking plead of the same. Praise the Lord. This after 1 week.
Your Lordship, one request is there regarding last order dated 27/8/2024.
Yes.
It is written that the request of Learned Council, respondent number 6, but there is no respondent number 6.
Only 4
But
respondents.
petitioner took time, Your Lordship, last occasion, but
Why
it is,
it's 1/6 written here?
yes, wrongly it reflected respondent number 6.
Immaterial Lordship, that order.
It has been brought notice of the court in the same order that in the last order, requests for adjournment been sought by the petitioner of number 6. And moreover, no responsive exists in the said case. The said order will stand corrected accordingly.
Deeply obliged, Your Lordship.
29.
Yes, can you accommodate him somewhere else?
Yes, Your Lordship, the government has submitted a proposal for creation of a supernumerary post, Your Lordship, to accommodate him as a grade 4 employee in the same school, Your Lordship.
Is that
So we have
alright?
got this letter. I can give a copy to my friend also, and this is the original.
He'll accept it.
I have to take instruction, Your Lordship.
Because
He doesn't accept it, at least he'll get
Because
one.
Your Lordship has said even in a contractual
Yes, because-
employment, he can be accommodated.
Yes,
So now they've created a
today
supernumerary.
on instructions, MST Young and EAG has produced letter dated 30/8/2024, whereby a proposal for creation of a superannuary or
It should
supernumerary.
be supernumerary.
Yes.
This, we have made a mistake here.
It's mixed up with with
Superannuation.
superannuation. A supernumerary post in Haldibari school to accommodate. Oh, no, sorry. For creation of a supernumerary post of grade 4 in Haldibari school to accommodate the petition.
The school has only 2 numbers of teachers and 99 students. So
Yes.
that
Yes,
is why there is no other
of
vacancy.
yes. So the same is taken on. You have a copy of yourself and made part of the records. But when will the proposal be?
Implemented, Your Lordship.
Because it's already sent from yes, sent from, it will be approved. Yes, just the matter after
When did Your Lordship?
3 weeks
3 weeks.
to enable the petitioner also to take instructions. You accept it
Yeah, sure. Much
because he's not qualified. He won't get a job. Now he'll get nearly 4 lakhs a year.
Lordship.
almost 30,000 a month. Your Lordship.
Yes.
Second call, item 4.
Yes, Your Lordship.
Election. They want to assure you. As a sort of, huh? Can I appreciate it? Family. I'm not.